As you earlier mentioned, we now have Kipchumba Murkomen, Elgeyo Marakwet Senator. He's joining us from our Eldoret studio. Mr. Senator, can you hear me?
Yes, I can hear you, Linda.
Okay, you're faint. Could you speak up just a little bit? And here is where we begin this conversation. There is a lot of concern about the use of recanted evidence, and there is all these efforts to try and ensure that this is overturned. Why is there so much concern about this rule?
Our concern is that the overarching concern for us is the fact that the ICC has been changing rules. You know, the rules have been shifted from every time when the case is almost coming to an end, there is a change of rules. And the concern about Rule 68 is the fact that you have a situation where there are witnesses who signed certain statements. Now, when they came to court, or when they were asked to come to court, they denied those statements, they recanted them, and said that really those were false statements. They have not even the courage to face their own statements in court. Now the rules are being changed to mean that such statements, which have not been cross-examined by any lawyer, remember that the prosecution has closed her case. So the fact is that even the lawyers of Ruto and Sang have not had an opportunity to cross-examine those witnesses. Now they are saying that you admit them to be part of evidence as one way of forcing this case to go forward, considering that those people have come out outrightly. Two is that from a legal perspective, and as an international law lawyer who has studied international law, the point is this, that the rule on retroactive application of any law is not acceptable, whether it's in any domestic country, whether it is countries that practice civil law or common law. All over the world, the practice is that you cannot make rules today and apply to situations where that rule was not existent by that time. So the point that was given during the negotiation of ASP was that the rule was not going to apply to Kenya. It was an undertaking that was given by a judge who is sitting at the ICC.
Senator, was that categorical that this rule was not going to be used in the Kenyan cases? Because someone would expect Ruto's defense team to bring this up in court and say, when you were negotiating this was not supposed to be used in the Kenyan case. So far, we haven't seen that. So was that categorical that this was not going to be used in the Kenyan cases?
Linda, you know very well it was brought out in court. Unfortunately, the judges, because now they're using doublespeak, pretended that they were not aware of that undertaking. But we thank God that the Botswana judge has now taken responsibility. She even stepped aside from the case because her conscience was judging her, and she was unable to face that situation because she gave an undertaking on behalf of the judges and the court. Remember, that is an argument that Ruto and Sang lawyers have already made in the court, but the courts ruled against them. And that is why this week we are going to the final institution, which is the Assembly of State Parties, to be able to tell them that they must be able to make that position sanctioned in writing, to make it clear to the whole world and to the court that really the intention of the court was to maintain the standards of international law, which is that you cannot apply a legislation or a law that retroactively.
Hold on, before I bring you to
one side of the case.
Okay, hold on before I bring you to what you hope to achieve, because you understand that several leaders are making their way to the Assembly of State Parties. But then the judges used Rule 69, subsection 3, which essentially gives the trial chamber the authority to request the submissions of all evidence that it considers necessary for the determination of the truth. Does that make sense to you?
Rule 69, which Judge Osuji tried to apply. Yes. You know, remember, Judge Osuji dissented on 68 and then applied 69. Is basically, in that rule of 69, the idea is that you just take it like any other document for purpose of the record, so that you can be able to refer generally. But the manner in which 68 is drafted is that it would make it almost mandatory that the courts will consider it. But in 69, you just consider as by the way. the effect is not as mandatory as in 68. So the idea of 69, where even the working report was accepted by the court using 69 as a document of general application for general reference, but 68 has more stronger ramifications to the case because it is a question of admitting it as evidence as it is.
Okay, the judge may have used his discretion, but then he cited exceptional circumstances in the Kenyan case, that is the deputy president's case and Joshua Arap Sang's case. He says there are exceptional circumstances in this case that warrants the use of Rule 69 subsection 3. And if I may quote his ruling, he says, in considering the exceptional circumstances that warrant the exercise of the authority under Article 69, subsection 3, it may be helpful to begin with the submission in Ruto's defense papers, saying Ruto and the defense, on Mr. Ruto's instructions, have repeatedly made public pleas for the ICC to be given space to do its work. That is one. And then he says, two matters of significance are apparent from DP Ruto's defense submission. One is its apparent congruence with the prosecution's complaint that there is a concern that third parties holding themselves out as connected to Mr. Ruto have been engaged in actions intended to prevent the appearance of prosecution witnesses. And finally, probably one of the main reasons why he even considered this, he says the conduct in question include high-profile campaigns on the diplomatic front as well as parliamentary debates and resolutions. Notably, the chamber was once constrained to conduct a hearing as to the forensic consequences, specifically in relation to witnesses in this case. And he goes on to say that in addition to the foregoing actions and utterances from government sources, there is information to the effect that community leaders were similarly engaged in public utterances. This is his concern, and why probably this is leading to exceptional circumstances. He says such reported public utterances of community and church leaders and elders, depending on the particular cultural ethos of the given community, may contribute to the chilling atmosphere that witnesses may find intimidating. Do you think the Kenyan cases are an exceptional circumstance?
First of all, Linda, you know, you can even see the language the court is using. It says it may create an environment where it's intimidating.
Maybe in their opinion it is.
The point is that if the court, can you hear me?
Go on.
Yes, I'm saying if the court really thinks that there is anyone who is interfering with witnesses, that is a crime that is actionable under the Rome Statute. First of all, go ahead, bring the case that there is an interference. There are witnesses who are being intimidated. Charge the person who is intimidating those witnesses. Find him at fault. When you complete that process of finding fault on the person who is intimidating the witnesses, use then that evidence to say, as a result of this intimidation, we now want to go ahead and admit this evidence as it is. But you cannot say that on speculation on possibilities, that there is interference with the case, that in that imagination, and they are saying they may intimidate the witnesses, you use that may to go ahead and shall admit another evidence which should not be admitted in the circumstance. That's double speak.
Okay. Thank you so much, Kipchumba Murkomen, Elgeyo Marakwet, Senator, joining us from our Eldoret studios. Thank you so much for speaking to us on KTN Prime. But finally, before I let you go, hold on, Kipchumba. It would be unfair for me to let you go before I ask you this. We understand that several leaders are making their way to the Assembly of State Parties. What exactly do you hope to achieve in this?
Well, our objective is to do two things. One is to be able to make the position of this country scientifically clear, that the court and the ASP parties must be, which is the bigger body that established ICC, must make that clarification very clear to the court that that case, the Rule 68 was not supposed to apply retrospectively. Two is that we are going to demand, going by the manner in which these cases are being processed in the ICC, we are going to demand that the court put in place the independent oversight mechanism, which is provided for by the Rome Statute, so that it can oversight the court itself, because we believe that there is too much interference and gerrymandering in the ICC case.
You've said it yourself. You believe there's too much interference. Thank you so much for speaking to us on KTN Prime. Kipchumba Murkomen, Elgeyo Marakwet, Senator. Thank you so much for speaking to us.